Thank you for speaking with me, Professor Rogers. Could you begin by saying what first interested you in this complex legal and historical topic?
I've always been interested in the intersection between law and American social values. My most recent book, Before the Child Cases, was a book about the death penalty in Massachusetts. And I argued in that book that the ambivalence that Massachusetts settlers, colonists, had about the death penalty when they arrived on these rock-bound shores led them to extend greater legal protection to capital defendants, a move that eventually led to an expansive and a very pioneering due process that gave, as I said, greater protection to capital defendants. And eventually, in the 1970s and 80s, that led, of course, to abolition here in Massachusetts. So my argument was that, this intersection actually had, because I don't believe in the death penalty, actually had a good outcome kind of thing. When I finished that book, my colleague and friend Jim O'Toole suggested that he and I teach a course, an undergraduate course together. And I said, sure, great. It's always be more fun to teach with someone than by yourself. And so we came up with this course called Church and State. He was the church, and I was the state. So that was a standing joke in the class, at least. And so with that, I learned a great deal from Jim and from the students who took the course. I learned a great deal about this intersection here now between religion, certainly an American value, and the law. The conflict, again, beginning with the breakup of the Congregational Church and who owns the church and who owns the property and those kinds of things. And most interesting, at least as we work through the syllabus, most interesting to me, faith healing, spiritual healing. And so I came to that topic through this course and then decided, that this was something that I would like to write about. Again, because it followed in the sort of general interest of mine, which is to say the intersection of the law and American values.
Would you clarify the roots of the Christian Science belief in faith healing or spiritual healing?
Yes. Put most simply, Mary Baker Eddy, 1821, 1910, argued that God is perfect and created, therefore, a perfect world and perfect human beings, despite lots of evidence to the contrary. And that the understanding of that led to good health, a comfortable and prosperous life, and all things good, essentially. Her argument, a little bit more specifically, her argument was that Jesus Christ had left in the Bible a blueprint for how to achieve health. And the achievement came through prayer. And Christian scientists use the word prayer differently than do other religious denominations. That is to say, Christian Science argues that because God created this perfect world and we're all perfect, and it's a perfect spiritual world, what we need to understand, what we need to include in our prayer is that we know that this is the truth, that the perfect spiritual world is the only truth. There is, Eddy argued, no material reality. Men, she said, in Science and Health, a book she published in 1875, is men are not bones and flesh, but spirit, perfect spirit created by God. Therefore, illness is an error. And if you understand that and include that in your prayer what they call a demonstration of your understanding, then the illness will be gone, because you realize that the illness is material and therefore an error, and the only reality is perfect spirituality. Those premises in part sprang from Eddie's childhood, a childhood that was troubled by ill health that extended into her adult years, a childhood that was troubled in part by the breakup of stern Calvinist congregationalism, which led Eddie as an adolescent and lots of other people in greater New England to question whether suffering, physical, mental suffering, was indeed, as Congregationalists, Calvinists argued, was indeed a part of God's plan for you. That is to say, that suffering was a test of your faith. To overcome that suffering would be a manifestation to God that your faith in Him and in His power was strong and embedded in your body. Eddie, because of her illnesses perhaps, rejected that premise that suffering was part of God's plan, and instead rather argued, no, God has created this perfect world, perfect spiritual world. We need to realize that. There's no need for suffering. God didn't create us to suffer. God didn't create us as evil, right? God created this perfect spiritual world, and we are perfect. We need only realize that. The only thing I would add is, and you and I both use the term sort of interchangeably, faith healing and spiritual healing. Their argument is, Christian Science argument is, Eddie's argument was, that faith healing, for which she had disdain, was not the same as Christian Science spiritual healing. Because spiritual healing, she argued, A, had, of course, roots in the Bible, but B, could be demonstrated because from the outset, Christian scientists, and still practice this notion, every Wednesday night meet, and it is always on Wednesday night, every Wednesday night they meet and relate to other parishioners their healing experience. And that relation is recorded. That incident is recorded and then subsequently published. And the argument is that therefore, this is not about faith, but this is science, and thus the name, the Church of Christ, science, because if you have a question about the validity of spiritual healing, well, here it is. Here are thousands and thousands of testimonials from people who say that their illness, their broken leg, their eyesight, their hearing, their whatever has been has recovered, has been improved, has been perfected because of the faith that Christian scientists embrace, because God is perfect and so on. So it's not about faith, it's about science, it's about evidence. Now, scientists in the outside world argue that, of course, this is really only anecdotal, right? That there are no blind tests, there are no, but anyway, they make the argument, and Eddie makes the argument from the outset, and it's been continued. They make the argument that this is what makes it different from faith healing, that this is scientific, and therefore they call it spiritual healing.
Much of your argument seems to rely on the legal distinction between religious belief and religious conduct. Can you explain the precedent for this distinction?
I would begin by calling attention to John Locke, 17th century English philosopher, political scientist, who, as we know, rationalized, legitimized the Glorious Revolution and the transference of power, or greater degree of power, to the people of England from the monarchy. Locke realized when he wrote the second treatise on government, he realized that religious toleration had to be justified and legitimized as well. You remember that the war, the Glorious Revolution, and the Civil War that preceded it involved Church of England and Congregationalists, Calvinists, those folks. And of course, Europe had been pockmarked for decades, for a century, by religious wars. And Locke argued, he made 2 points. He argued, if we get along in the marketplace, evidencing the fact that trade had become England's brand mark, right? If we get along in the marketplace, if we're willing to buy and sell goods to anyone who has the wherewithal to carry out that transaction, if we get along in the marketplace, why can't we get along in terms of the different faiths that we have? We don't ask the man, in other words, from whom we're buying a barrel of apples, what faith is he? We ask the price. And if the price is agreeable, then we make the purchase regardless of what religion he or we are. Locke extended that argument by saying, yes, there's religious toleration, and that helps the marketplace operate smoothly. It also diminishes the likelihood that political divisions are going to be tied to religion, and bloodshed, therefore, as we all know. But Locke said, and articulated what he and other scholars have subsequently labeled the harm principle. Locke essentially said, yes, you can believe this, but you may not deprive a person of his life or anything that helps his life. You may not harm that person. You may not take that from him. So that bolsters, as it were, the toleration principle, right? Yes, you have to tolerate, but you also have to say to yourself, and you also have to act in a way that doesn't harm that other person, right? So it's a pluralistic society. It's a pluralistic religious world. Let's recognize that. Let's tolerate one another because that's the reality. But no harm should come of that. We must listen. We must understand. We don't have to necessarily interact, but we may not harm. We may not take from the person his life or anything that supports and makes healthy and good his life. That harm principle, an enlightened principle, picked up by, among others, Thomas Jefferson and James Madison in the United States, what was to become the United States. Jefferson said, echoing Locke, government legislates actions, not opinions. Government legislates actions, not opinions. And the subtext, of course, would imply that religion was an opinion, right? And so here is the beginning of the distinction between a belief and action. In 1785, Madison took that a step further and made an argument for separation of church and state. Because, he argued, echoing Jefferson, because, right, the state should have no business in legislating about religion. It's not a matter that the state should become involved in, entangled in. And he argued that to do so, or to have the church involved in the government, given the fact that it's a pluralistic society, to have the church involved in the government or the government involved in the church would be counter to the fundamental principle of the republic, which was equality. So those arguments, really all three of those arguments, are integrated into American constitutional law in 1879 in a case called Reynolds v. U.S. George Reynolds was a Mormon who agreed to test the United States Congress's law prohibiting polygamy, then a belief of the Church of Latter-day Saints, of Mormons. And the Supreme Court of the United States in 1879 said, made this distinction. Mormons may believe, all religions may believe whatever they want. The government will not interfere in any way, shape, or form into anyone's belief. But the government reserves the right, the state reserves the right to regulate actions if necessary. And this is where Locke's harm principle comes in, because the court argued polygamy harmed women, right? It demeaned them, it put them into an unequal position with other women, and so on, right? So therefore, and they also, the court also cited Jefferson and Madison on this same point, right? So that from 1879 into the 20th century, that separation, that argument that you may believe whatever you want, but you may not necessarily be able to practice that belief, was the premise on which the Constitution operated vis-a-vis religion. In 1944, in a case called Prince v. Massachusetts, a case brought to the Supreme Court of the United States by Jehovah's Witnesses, not Christian Scientists, the court said, briefly the details was, a woman guardian took her child out onto the streets of Brockton to sell pamphlets, The Watchtower, Awake, which was a primary practice of witnesses who were witnessing their belief after all. The fact that she took this underage child, she was 12, took her out onto the streets of Brockton at night, conflicted with the child labor laws of the day. So she was arrested and charged with violating this law. She appealed, and the Supreme Court said, here, you may believe whatever you want, but you may not necessarily act on it. Specifically, you, the parent, the guardian, may not impose a belief on a child that harms the child. Having the child out on the streets late at night is a violation of the child labor law. The child labor law is a generally applicable law, neutral law. That is to say, it was not enacted to specifically aimed at Jehovah's Witnesses, but it was a law aimed at the protection of all children. The state has assumed that obligation of protecting children. So, therefore, it can be regulated, right? The practice of Christian Scientists, Jehovah's Witnesses taking a child out at night can be regulated by the state. More importantly, the court said, a parent, an adult, is free to martyr themselves, but they may not impose martyrdom on a child. So here we see an extension, in other words, of that, and an assimilation of that harm principle, and an extension of the court's notion that you may believe what you want, but you may not necessarily be able to act on it. One more case, and then we'll... this argument is changed, is altered by the court. This argument about the separation of belief and action is altered by the court in a case called Wisconsin v. Yoder in 1972. At issue here was whether Amish parents were obligated by law to send their children to school until they reached the age of 16 or graduated from high school. Amish parents argued that because their children, like they, were going to lead a simple life, a simple agricultural life, they didn't need any education beyond the 8th grade. That, of course, ran counter to the Wisconsin law that all children must attend school until they reach the age 16 or graduate from high school. The Amish argued that that law violated the First Amendment's guarantee of the free exercise of religion. And the Supreme Court, 1972, agreed. That is to say, they said, in order to preserve their religion, in order to protect and extend their faith, we believe the Amish should be allowed to remove their children from school at age 13 or 12, 13, 8th grade, and not be required to go until 16. The education that they receive after middle school, the court said, was too worldly, too complex, too likely to undercut their faith, and therefore were opposed. And the court agreed. The court added, not only did the decision, in other words, apply to the specific requirement about education, but the court added that the free exercise of religion, a way of life, was protected by the Constitution, by the Free Exercise Clause in the First Amendment. That phrase, a way of life, opened the door to many other claims by religious groups who claimed that legislation infringed upon their way of life and therefore infringed upon, restricted the free exercise of religion. We know Hobby Lobby, for example, doesn't exactly rest on the First Amendment. It rests on the Religious Freedom Restoration Act, but it's the same point. And I think that's, in a sense, where we stand now, that division between belief and action still stands, but it has been tempered first by Wisconsin v. Yoder and subsequent cases.
If there were successful manslaughter convictions in the UK and in the US for child neglect cases overriding religious exemptions back to the late 19th century, how did these justifications continue throughout the 20th and even into the 21st century?
Yes, the cases that you talk about or cite in the UK, beginning in the late 19th century, with a group called the Peculiar People, a group called Peculiar because it cites a biblical citation saying those people who embrace Christ, who embrace God, will be regarded as peculiar people, not odd people, but peculiar in the sense that they understand the relationship necessary with God and with Christ, whereas others don't. The peculiar people believed in faith healing, and so when their children fell ill, they prayed. Sometimes used a little anointing oil or whatever, but they prayed. A couple of cases came to the English court, to the court of the King's Bench, and in the first, involving a young couple and their child over whom they prayed, and the child died, the courts instructed the jury as follows. They said the key question was that the juror should decide. The key question was the actions of the young couple about their sincere belief in their religious faith? If it was, then they should find the couple not guilty. And in fact, that's what the jury decided. Subsequent to that, the law was changed because there was an outcry, and the Parliament responded to that outcry, that public outcry, by changing the law, the so-called Poor Law, and adding that it was necessary for parents, it was required by law, in other words, for parents to supply their children with food, clothing, housing, and medical care. So that in 1898, when a man named Thomas Sr., also a member of the Peculiar People group, when he was brought to court for this, arrested for the same offense, that is to say, allowing his ill child to die, that is to say, not seeking medical care, he was found guilty. And that then led, I argue, to the enactment of similar such laws in the United States. So in 1903, in a case called Pearson v. New York, a laborer, again, a relatively poor person, a laborer had embraced a particular faith, not the Peculiar People, but another faith, had embraced a faith which followed the same premise. That is to say, prayer was the only permissible, religiously permissible way to treat illness. Pearson's daughter died of whooping cough, obviously a highly contagious disease that cut down thousands of children. And he was arrested and brought to court. He argued, free exercise of religion. I have a right to my faith and to the practice of my faith. Therefore, he argued that the law that New York had passed requiring parents to provide medical care was unconstitutional because it violated his right to free exercise. The court rejected that argument and upheld the law, the New York law, and that then became a precedent for such laws across the country. But it was one thing, as we know, to pass a law. It's another thing quite to enforce it. Enforcement was difficult because the state, among other reasons, because the state wasn't sufficiently developed, wasn't sufficiently bureaucratic to note the deaths of children, certainly infants, also adults. And as I say, there wasn't a systematic registration, there wasn't a systematic analysis, there weren't autopsies necessarily performed, and so on. So yes, the law was on the books, which prohibited, which demanded that a parent seek medical care, but if they didn't, it likely slipped through the cracks of the state and of state regulation, and therefore not much was done. The women's movement revitalized that law in the early 20th century. In other words, when women were seeking the vote, when they subsequently gained the vote, but when in the run-up to their effort to win the right to vote, they embraced, or some parts of the women's movement did it anyway, embraced lots of other issues, including, and it sort of follows, I suppose, including the right to protect children. This led, that part of the women's movement led to the creation of the Children's Bureau, a bureau in the United States government, not a cabinet position. Women were not yet that equal, but a bureau, but which gave women the power to propose legislation about orphanages, about right to work, about child labor laws, and so on and so on. And they used those rights and the Children's Bureau to reintroduce the notion that the state should take an active role in protecting children. World War I, the Depression, the New Deal, I hurry through here, led to new programs to protect children from poverty, but not specifically from abuse, from parental abuse, from denial of medical care and death. And that was the case until 1962. So a long hiatus between these early progressive arguments that the state needed to act in its role as parent of the country to protect children, that it was a compelling state interest, in the words of the law, to protect children. Pearson v. New York, 1903, but between 1903 and 1962, little or nothing was done to actually implement those laws and that ideal. 1962, an article published called The Battered Child Syndrome brought back into American consciousness the idea that children needed protection. And as data demonstrated, they needed protection specifically from their parents. It shocked the American conscience in 1962 and then the decade after to learn that hundreds of thousands of children every year were battered to near death and to death by their parents, often by their parents, sometimes by others, but predominantly by their parents or a parent. This led to congressional legislation. So in 1974, the Congress of the United States passed a law called Child Abuse Prevention Treatment Act, as Congress, well, it used to be given to passing laws, but as Congress is given to these kinds of acronyms. CAPTA was a law enacted by Congress to try to stem child abuse, to try to introduce protective measures which would help treat this epidemic of abuse. Interestingly, and this is where we come back to Christian Science, Christian Scientists were able to insert into the regulations accompanying the law an exemption. That is to say that Christian Scientists, would not be subject to discipline, to arrest, to fine, for abusing their children, i.e. withholding medical care from them. For that reason alone, they would not be so charged. The measure was inserted into the regulatory code that accompanied the law, it's believed, by two of President Nixon's advisors, whose names I've just forgotten, Haldeman and Ehrlichman, and both of whom were Christian Scientists. So these two highly placed men were able to put this regulatory measure attach it to the law, and more importantly then, require every state who wanted funds from the federal government to create protective programs for children to insert into state law the same measure, that is to say, to exempt from prosecution Christian Scientists. Quite a triumph for Christian Science lobbyists. So I guess to sum up, we go from recognition that the state has an obligation to protect children, but that obligation, that responsibility is not well implemented, to say the least, not well implemented by the state. The revival then of interest beginning in 1962 in child abuse, the passage of a law passed by the Congress of the United States, but including an exemption that puts into jeopardy any number of children.
I was surprised to read that the vast majority of states still allow a religious exemption to child abuse laws even today. Why do you think that the repeal in Massachusetts hasn't spurred more successful efforts?
Well, certainly those advocates, those children's reform advocates who did successfully repeal the religious exemption in the Massachusetts statutes and therefore make it mandatory that a seriously ill child receive medical care. Those people who worked for at least 6 years to achieve that success, they certainly harbored the hope that if Massachusetts took that step of repealing, that other states would follow. That hope was not realized, except in a handful of cases, and mainly there were local experiences that led to the other states, a handful of other states, to repeal, rather than the Massachusetts example. So, in other words, the bottom line is the reform had to be carried out, had to be struggled through, had to be pushed through a legislative body in each and every state. In other words, there was no magic bullet, there was no silver bullet, there was no single act that could repeal these laws. Secondly, for the first decade that CAPTA, Child Abuse Prevention Treatment Act, for the first decade, CAPTA required states not only to put on the books, but in every succeeding year from 1974 to 1983, almost a decade, the federal government required that states maintain that exemption in their statutes, else they got no money. So Hawaii, for example, where child abuse, I was surprised to learn, in paradise after all, was rampant, that they ranked, I don't know, something like 4th or 5th in the nation in terms of child abuse, despite, the relatively small population. They were brought to repeal by the concern that they would lose federal funding if they didn't. So that when the law changed in 1983-4, Hawaii rushed to repeal, not because out of some swell of humanitarianism or care for children, but because they would lose money if they didn't. Perhaps that's a reasonable course of action. Then CAPTA, when they repealed the exemption in '83, CAPTA said, well, you don't have to put in the exemption, but you may, right? So what that did was leave the door open for states to do nothing. So the exemption stayed on the books in all but a half dozen states after a couple of decades of effort. Christian Science Church was extraordinarily skilled in lobbying, not only at the national level. The church maintains at least a dozen lobbyists in Washington year-round, and has for some long time, for some decades. They maintain a lobbyist in each and every state, a single lobbyist, sometimes two. They are able to rally their parishioners to lobby the legislature. Their argument is that we in America believe in freedom of religion, and that these laws are necessary to protect our freedom of religion. Without thinking much beyond that, legislators are quick to approve exemptions for spiritual healing, perhaps unaware of the damage that legislation sometimes causes. So their effective lobbying is another reason why it's so difficult. Another reason is, a final reason is, and this was explained to me by a lobbyist, the other reason is it's easier to pass a law, he explained to me, than it is to remove one, right? No one, he said, wanted to stake their career on taking a law off the books. First of all, his constituents have no idea what the law is and couldn't care less. And secondly, it's tough to convince fellow legislators that something of that sort should be done. In other words, it was enacted, and so what the heck, that's good to stay, right? So even when there are hearings which demonstrate the danger of such a law, demonstrate the death that such a law brings, nothing happens.
Can you speak a bit more about the actual children who've been directly impacted by this religious exemption?
Yes, it's easy to speak about the law and about the court cases that follow from the law, but difficult to speak about, to read, to write about, to speak about the horrible outcomes that spiritual healing sometimes led to. In the late 80s and early 90s, 8 children across the country, in that short period of time, 8 children across the country were left to die while their parents stood over them with a demonstrative prayer, or a practitioner phoned in a prayer to a child suffering a death that need not have happened. In other words, the death of these children was not from some exotic, can't be cured, my gosh, there's nothing we can do about this, but they were from ordinary childhood diseases which could have been cured, could have been saved, had the parents taken the step to take the child to a hospital. That didn't happen because they believed, the parents believed in spiritual healing and insisted to the end, to the moment when the child drew its last breath as they stood over them. And in fact, after that last breath, because scientists also believe that it's possible to resurrect a child, an adult, a person who has what we would say die. There's a picture in my head of a small child brought to a practitioner by his Christian Science parents. The practitioner lay the child on the floor of her home in order to pray, in order to impose her spiritual healing that she hoped would bring about the child's healing. And she told the parents to go for a walk. So as this child lay on the floor, struggling for breath, the practitioner prayed, that is to say, demonstrated her belief that spiritual healing was God's only way of achieving healing. She prayed, the parents walked around the block. When they returned, shortly, almost immediately after their return, the child drew its last struggling breath following a convulsion and vomiting, and died. No thought was given, the court records tell us, no thought was given to calling an ambulance, to calling a physician, to picking the child up and putting it in a car and racing to the hospital. No thought was given to that. And, for a parent, honestly, and it's a job of a historian to be objective, but for a parent to read that, I just couldn't believe that it was possible. I know about deep faith, but it seems to me, my subjective opinion is, it seems to me at some point, and the point obviously could be recognized by any of us, that the child was in trouble, that the child was near death. At some point, you would put aside your faith, you would compromise, you would rationalize, you would pick that child up and race it to the hospital. Right? But that didn't happen. Then the parents, the child lying dead on the floor, then the parents, by instruction from the Mother Church here in Boston, which supervises the deaths of children across the country. In other words, nothing can be done until the official here in Boston is informed. And the official here in Boston told the parents in California to call a funeral home, knowing, he did, Talbot, knowing that that was wrong, that was illegal. A funeral home cannot pick up a body unless the police first or a medical person first legitimizes the death of the child. But they called the funeral home, then turned the hearse away when the hearse arrived because they were still bent on trying to resurrect the child. It just goes on. I mean, these are tragic, horrible stories because of the law, because of the exemption. And I have nothing but praise for those people here in Massachusetts, Jetta Bernier and Rita Swan, not a Massachusetts person, but a head, and others who have given their life, really, their professional life, to try to repeal these laws, which they and all other reasonable people have concluded imperil children.
I'm curious if you draw any connection between the argument that religious exemptions violate the no harm rule and are inconsistent with the public good and other similar debates about medical intervention and public good, like vaccinations.
Short answer, yes. Yeah, and in fact, it's the book I'm working on now is about vaccination. Yes, it's remarkable. 16 states now have laws that provide exemptions, religious exemptions, and philosophical exemptions to parents who claim that they are opposed to vaccination. All the rest, save 2, all the rest of the states in the United States, save with the exception of 2, have religious exemptions. 16 have religious and philosophical. All the rest have religious exemptions. To some school districts in Washington state, at least I know, some school districts pass out to parents a form that allows parents, all they have to do is put their initials on it, to initial it, a form that allows them then to exempt out of vaccination and still be able to enroll their children into kindergarten and the first grade. It's mandatory in every state that children be vaccinated before they enter school. But the number of exemptions has soared, in part because of religious reasons, but more also in part because of the fear of the of injury, of the sometimes disastrous consequences which result from vaccination, and from the misplaced fear that there is a connection between vaccination and autism, a claim that's been repeatedly proved to be without scientific basis, but has had no effect on the fear of parents. I understand the fear of parents, but it is in the public good to have children vaccinated, not in the public good to have unvaccinated children in school. In Washington state, 2 years ago, there were 6,000 cases of whooping cough, a potentially fatal disease. In fact, some 30-some children died from whooping cough, unvaccinated, in other words. That doesn't make sense, but there it is. Yes, so yes, it's a phenomenon that exists here in this ordinary, everyday practice of vaccination, and with similar perils.